All right, so Mr. Green, can you raise your right hand for me, please? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Can you state your full name for the record, please?
Andrew Michael Green.
All right. So, Mr. Green, you heard the statement of your attorney. Is it your intention to plead guilty to this violation of probation?
Yes, Your Honor.
All right. Now, you had an opportunity to speak with Ms. Underwood. Are you satisfied with Ms. Underwood as your attorney and the advice that she has given you?
Yes, Your Honor.
All right. Now, do you understand that you do have a right to contest this violation of probation charge and to have a trial on it? Do you understand that?
Yes, I understand.
Do you understand that throughout this trial, you would be presumed innocent until your guilt is proven by a preponderance of the evidence? Do you understand that?
Yes, I do.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you might have to appear at that trial. Do you understand all that?
Yes, I do.
All right. Do you understand that you do not have to testify at your trial and no one can say anything about you not testifying or hold it against you in any way? Do you understand all of that?
Yes.
On the other hand, do you understand that you have a right to testify at your trial if you want to testify?
Yes, I understand.
All right. How do you plead to the charge that you violated the terms of your probation by failing to report upon release from jail to the probation department or any time thereafter? Guilty or not guilty?
Guilty.
All right. Do you understand that by pleading guilty, you will be giving up the right to a trial, as I've already explained to you?
Yes.
Has anything been promised to you to get you to plead guilty?
No.
Has anyone threatened you in any way to get you to plead guilty?
No.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes.
Is it your own choice to plead guilty?
Yes.
All right. So, Mr. Green, you were sentenced back on September 8th of 2022. And I gave you credit for time served, and I ordered you to report to the probation department that day as soon as you're released, right?
Correct.
All right. And did you report to the probation department that day?
No, I did not. No,
Okay. And then did you report the next day?
No, I did not.
So, and in fact, you never reported at all. Is that correct?
Yes, I didn't report, and then I was lodged in Jackson on October 1st, and I've been
so
there
like a month later. So you had about 28 days to report. Just didn't do it, right?
The 8th. Yeah, 20. Yep, 20 days. Yeah.
Okay. All right. I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. I'm going to refer this matter to the probation department for a probation violation report. Ms. Adams, when is my next available sentencing date?
We were using March 16th at 8 a.m.
Is that full, or do I have room, or do I need to go to another day?
You have 3 and drug court at 9:30.
So we're going to set this for sentencing on March 16th at what time, Ms. Adams? 8?
Yes, Judge.
So we'll set this for March 16th at 8 a.m. for sentencing. Someone from the probation department will be over to see you, be truthful with them. They'll prepare a report. We'll get a copy to Ms. Underwood and she'll review that with you. And we'll see you back on March 16th at 8 o'clock in the morning. Thank you.
Judge,
All right.
can I
All right,
speak
thank
with
you.
him just for a minute?
Yeah. Not long though, because I got
Yeah.
back up at the jail.
Okay.
All right. So, all right, Ms. Walsh, I'm going to open up a breakout room for the two of you.
Oh, Connor, that's the victim of the Casares release.
All right, Miss Underwood? Mr. Murphy?
Morning, Your Honor.
Could anybody text Mr. Malaro and tell him he's now 39 minutes late? And I got all those people in the waiting room.
Judge, he just messaged me that he can't get on Zoom. I don't know what's going on.
Oh no, Mr. Murphy, you want to take his cases?
No, I'll go see if he wants to use my computer, though.
Is he in the building?
I think so. I'll go check.
Okay. All right, Mr. Murphy, you have Bryce Russell. Want me to take care of that one, Mr. Murphy? All right, well, Miss Underwood, we can take care of Mr. Vela.
Whom would you like first, Your Honor?
Let's see, who do I got in jail? I have Evelyn Bell. I think Evelyn Bell is, let's see, the last one I need from the jail, I think.
I will get them in here.
All right, thank you. So, Ms. Underwood, in the matter of the people of the state of Michigan versus Israel Vela, file number 2021-20198FH. Ms. Underwood, this is the time scheduled in this matter for sentencing on violation of probation. Is that correct?
I believe so, Your Honor.
Now, Ms. Underwood, you did such a great job that you convinced me to release Mr. Vela and send him to rehab. And I think he even said, and I will love this for the rest of my life, that he was gonna go because he knew what kind of cookies I had in my cookie jar and he didn't want none of it, right?
That is, I believe, an accurate representation of Mr. Vela's statement, Your Honor.
Yeah, so Mr. Vela never went. So I am going to issue a bench warrant for him because he's also he has failed to appear today. So I'm going to issue a bench warrant for his arrest and I am going to set no bond. So
Well, that would be a cookie, Your Honor.
that would be a cookie. So Ms. Underwood, what else do you have this morning?
I believe I have Mr. McCullough.
That's at 9 o'clock.
Okay, thank you, Your Honor.
All right, thank you.
I think I missed what had happened with Mr. Austin.
Mr. Austin requested court-appointed counsel, but he had a conflict attorney. So Ms. Underwood is trying, or Ms. Adams is trying to reach Mr. Daly.
Okay.
right, all right, okay. Ma'am, are you Evelyn Bell?
Yes, I am.
All right, Mr. Malaro?
Yes, Judge.
Good morning. So I have Miss Bell here today. Miss Bell has some contempt of courts for failing to drug test, and she let's get a warrant for failing to drug test, and then a contempt of court warrant for failure to appear for sentencing. Miss Underwood did meet with her and asked that it be set today because you were her attorney. She failed to appear for sentencing, and we do have a PSI. Do you have a copy of it? It's a district court probation report. Did you get that?
Yeah, Judge, I have one from before.
I have January 5th of 23 was the
Yeah.
date on it.
But she,
Okay.
I didn't know if it was going to be updated because now that she's in custody, they could talk to her. Because the one we have was she didn't, they were saying she didn't show up for her interview.
Do you want it adjourned so that they can interview her?
Do you want it adjourned, Miss Bell, to be interviewed, or?
It just depends because I called my job since I've been here in custody, and they said as long as I can be out by this coming next week, I can save my job. So.
All right, well, the recommendation, Ms. Bell, is 12-month
Well,
probation.
Mr. Malaro, do you want, well, she also has contempt of courts for
Okay.
violating her bond conditions as well as failing to appear. So do you have those, Mr. Malaro?
I do.
So
Perhaps
she
I
was
could
failing.
do a quick breakout with her, Judge.
Yep, I'm gonna put you in a breakout. All right, so Mr. Malaro, I'm gonna put you in a breakout room with jail.
He's on his way over.
Thank you, ma'am. Do you want these ones? Is he gonna see Mr. Austin?
Yes.
He's gonna Zoom?
I think he's on his way.
Okay. Awesome. All right, Mr. Murphy. Oh, you didn't join, okay, hold on. Ma'am, you're in a room, you gotta use the mouse to join the breakout room. There you go. All right, Mr. Murphy,
Yes, Your Honor.
I have Mr. Bryce Russell. So this is in the matter of the state of Michigan versus Bryce Divine Russell, file number 20-20090FH. I have Matthew Murphy appearing on behalf of Mr. Russell. I also received an updated case report from the Michigan Department of Corrections that basically states that he did pick up his pre-sentence packets and was given a date to return. He lost his packets, so he said, I need more packets. So they set up that for him, but he never picked up the packet. And then he never came in on December 13th to do the pre-sentence report. They have tried to contact him and they've been unable to. He's failed to appear for that. He failed to appear for sentencing on January 20th of 2023, and a bench warrant was issued. He turned himself in, and I quashed the bench warrant, and we rescheduled sentencing for today. And let's see, he did go, he went and got another packet, but then he failed to report for the pre-sentence date and for today as well. Do you have him?
I do not, Your Honor. I haven't been able to contact Mr. Russell, so unfortunately I can't update the court with any more information than the court has.
All right, so I am going to issue a bench warrant for Mr. Russell and with no bond. All right,
Thank you, Your Honor.
Obviously, if you find him again, he's not in my courtroom. Let me know.
Yes, Your Honor, I will. Thank you. Everyone have a good,
Thank you.
good day, and I hope everyone's safe with the snow coming. So,
Thank you.
There's not gonna be
You too.
snow. It's gonna be a mild amount of snow that is not gonna impede me from going to see El King tonight at the Fillmore. That's, yes.
well, that's what I
agree.
believe it's gonna be maybe an inch. That's what I'm saying. So,
Yeah, let's be real. It's Michigan. They say 5, it means 1.
Yeah.
Right.
So,
Yeah.
Everyone have a good
but we
weekend.
Get
Be
excited
safe.
about the storm. All right, bye, Matt. Let's see. I'm gonna go grab a coffee while we're waiting.
Oh, oh, it was?
Yeah.
Um,
Shocker. I got two today too. Oh, no.
All rise.
All right, Ms. Russell, you want to come up to the podium? Pull your hat off. I know you can't wear it in the courtroom. All right, so this is in the matter of the people of the state of Michigan versus Rights to Bind Russell, file number 20-20090FH. Mr. Malaro, can you shout across the hall and tell Mr. Murphy to log back on? Now, Mr. Russell, I don't like chasing people, and I know you got a lot going on in your life. But you know I don't like chasing people. So, tell me why I should not take you into custody today.
The reason why you shouldn't take me into custody because where I was living, people got evicted and all my stuff was put somewhere where I couldn't really get to it. And my transportation situation is really bad. I walked all the way from
Okay. Speak up. You gotta be a little bit louder, Mr. Russell.
I came to try to talk to her a couple times and she was like, call the phone about 3 times.
Mr. Russell, so you need to speak loudly into the microphone.
Yeah,
Move it.
I tried to make contact and said, not for nothing bad, but I was trying to let her know what's going on, but I left the message on her phone a couple times, but.
No, you didn't.
So, Ms. Russell, I would tell you that I doubt that because Miss Walsh is one of those that will always follow up. So, all right, so you just have a seat and we'll get Mr. Murphy back, all right? Right there, yep, sit right there. Okay, all right, Mr. Malaro.
Yes, Judge.
Yes.
Okay, so back on the record in the matter of the people of the state of Michigan versus Evelyn Marie Bell. So we have 3 issues today. One is sentencing and contempt for failure to appear and a contempt for failure to comply with bond conditions. So, Mr. Malaro, how do you wish to proceed on the contempts?
Judge, Ms. Bell will be admitting the contempt violations.
All right, so Ms. Bell, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, can you state your full name for the record?
Evelyn Marie Bell.
Okay, now, Ms. Bell, do you understand we have two contempt of court today? You can put your hand down. One contempt of court is that you failed to appear for sentencing on January 12th of 2023. Report to the court anytime after that. The other one is a contempt of court for failure to comply with your bond conditions, which we'll put in place, and that you failed to report to Mr. Coast on November 30th of 2022 at 11:30 a.m. for drug test, and then you failed to test 3 times a week as ordered, and then on November 30th or December 2nd or anytime thereafter, and then you failed to return telephone calls from Mr. Coast. So you understand you have those two contempt of courts?
Yes.
All right, now, Ms. Bell, do you understand the maximum penalty for contempt of court can be up to 93 days in jail and or a $7,500 fine? Do you understand that?
Yes, I do.
All right, so Ms. Bell, you will understand that you do have a right to contest both of the contempt of court charges and to have a trial on.
Okay.
You understand that throughout the trial, you would be presumed innocent until your guilt is proven by a preponderance of the evidence. Do you understand that?
Yes, I do.
You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions. You may ask them yourself, and to have me order any witnesses you might have to appear at that trial. Do you understand all of that?
Yes, I do.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, I do.
All right. Do you understand, on the other hand, you do have a right to testify at your trial if you want to?
Yes, I do.
All right, how do you plead on the contempt of court for failure to appear, that you failed to appear for sentencing on January 12th of 2023? Guilty or not guilty?
Guilty.
And how do you plead to the contempt of court that you failed to report to Mr. Coast and drug test as ordered? Guilty or not guilty?
Guilty.
Has anything been promised to you to get you to plead guilty?
No.
Has anyone threatened you in any way to get you to plead guilty?
No.
If I accept the pleas, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, I do.
All right. Is it your own choice to plead guilty?
Yes, it is.
Now, Ms. Bell, when you took the plea on the record at that time, I told you that your sentencing would be January 12th of 2023. Is that correct?
Yes, it is.
All right. I also told you to report to the District Court Probation Department, probably on Thursday of that week or the next week. Is that correct?
Mhm.
Yes?
Yes.
Okay. And did you fail to report for sentencing on January 12th?
Yes, I did.
All right. And did you ever report to the District Court Probation Department for your pre-sentence interview?
No, I didn't. I apologize for that.
Okay. Now, you were also required to drug test because your case involves drugs. So you were supposed to report to Mr. Post, who is our pretrial services coordinator, to take drug tests 3 times a week. Is that correct?
Yes, it is.
All right. And did you report to him?
No, I didn't. I apologize for doing that, but I am clean.
Okay. All right. I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. So, Mr. Malaro, with regard to the underlying sentence, is she wanting to proceed to sentencing today, or does she want an opportunity for Mr. McCarron to prepare a report?
She wants to proceed with sentencing today.
All right. So, Ms. Bell, have you had an opportunity to review the sentencing report from district court with your attorney?
Yes, I have.
Now, you understand, since you failed to appear for that sentencing investigation report, we have really no information about you other than what happened in the police report. You understand that?
Yes.
All right. Okay, what was the warrant? Was that district court warrant 22-1713? Has that been taken care of, Mr. Malaro?
She tells me it has, Judge.
I've been PR'd and that.
Okay, all right, so Mr. Malaro, does the pre-sentence, or do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Yes, Judge, we'd update her, her address to the Adrian Inn. It's transitional housing. And she is employed at Martin's Ria in Manchester.
Okay. All right, and anything else?
No, not with regard to accuracy, no, Judge.
Okay, does, there are no guidelines because it was a plea to a misdemeanor. Before the court passes sentence, either on the contempt court or on this one, is there anything you'd like to say on her behalf?
I would, Judge. First, yes, I just had a discussion with her about the importance of making sure she maintains both contact with her court and with her attorney in the event something occurs, not to just ignore it because it's not going to go away. That being said, Judge, even without the probation department having any contact with her, they're still recommending a 12-month probation with no upfront jail. She's been in custody now, I think a little over a week, or maybe just about a week. She has a job that she can maintain if she can be released. And she's local, so it's not like she's out of town. She did contact me after she missed her sentencing with a couple of emails. And she was, from those emails, I would state to the court, she was experiencing some economic issues that was making life a little difficult. I've explained to her that life sometimes does this to us, but maintaining contact with the court and her counsel would have really reduced any, potential incarceration that she would have faced in this case. Clearly, she's not looking to run because she's stayed in the area. So we'd ask the court to file the recommendation. I'd ask the court to consider giving her time served on the contempts. And perhaps she could be drug tested today or Monday just to make sure. And I mean,
Well, I know she'd be clean today if she's been in jail, so.
right, that's part of the recommendation anyhow. So I think Miss Bell is in a clear mind today, and I'd ask the court to take that all into consideration.
Great. Ms. Bell, is there anything you'd like to say in your own behalf?
I am sorry for doing that. I finally got on my feet. I'm in my own home now at the Adrian Inn. I pushed all my social security back to the side to get this job. I want to keep this job to prove to you that I'm doing better. And I will drug test anytime I have to. I'll do it before I go to work every day if I have to, just to be able to keep this job because I got my foot in the door somewhere that I don't want to lose.
What is the shift you work?
Second shift.
I don't know what time that is. 1 to 10?
Mm,
So, all right, you didn't show up for sentencing, you didn't do any of your drug testing, you didn't do anything I've asked. Mr. Vela says you didn't run. Well, you did run, you just didn't run far, which means we eventually will pick you up. So why should I believe that you're gonna follow through with this?
I guess that's on you if you don't. I promise this time I won't. I'm not that far from here. I have got somebody that I've been seeing that actually told me that I need to get my things taken care of before we moved any further into a relationship. And I really like this person. He brings out the old me. So I would appreciate that if you did this so I can show to you that I'm doing good, that I'm actually not wanting this.
All right. Okay.
Judge, I would say that given the fact that she, yeah, as the court described it, she didn't run far. If she messes up, I don't think the court has to go very far to find her. And I think Miss Bell knows that this is would be perhaps the last chance she's gonna have.
Yeah.
Show this court that she's serious about becoming a productive member of society.
All right, okay. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing, the criteria and reasons for the sentence and the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. On the underlying sentence, it's the sentence of the court that you will be placed on probation for 12 months. I'm going to order a $300 fine, $50 in state costs, $750 in court costs, $75 victim rights fee, $450 court-appointed attorney fee, and $30 per month supervision fee. During that term of probation, you're not to use any controlled substances, and that includes marijuana. Even though it's legal, doesn't mean you as a former drug addict or as a drug addict should be using it. So no alcohol, no illegal drugs, no opiates, no amphetamines, no marijuana. If you're given medication that is of the form that will cause you a false positive, you need to check in with the probation officer before you take it. Do you understand that?
Yes, I do. I do know I'm on Adderall every day. I do know that. That's the only pill that
Okay.
I'm on.
So you're going to need to provide to Mr. McCarron or the probation department a valid prescription showing that you take Adderall. Do you understand? And you can only take it as prescribed.
Mhm.
You must cooperate with all searches or seizures of any controlled substance, alcohol, or marijuana. Sign any and all necessary releases for information. You can't live anywhere where there's any controlled substances, alcohol, or marijuana. And I'm going to order that you have a drug, an alcohol assessment. And then that you're to follow any recommendations for treatment and counseling. Do you understand that?
Yes, I do.
All right. Nobody can do this on their own. You don't just flip a switch and quit using drugs. You got to have a help. So I'm going to order that. And you do have the right to appeal this sentence. We're going to send over to the jail 3 copies of your notice of right to appellate review. You're going to sign one form to acknowledge you received it. The other 2 are for you. If you wish to appeal the sentence, you fill out the information on the form and mail it to the address listed on the form within 42 days. Ms. Bell, I am going to set sentencing on the contempt of court for March 16th at 8:30 in the morning. And Ms. Bell, here's what I will say. If you reported to Mr. McCarron and complied with that, I'll give you credit for time served. If you haven't, I'm going to issue a bench warrant again. Do you understand that?
Yes, I do.
And then you're looking at a year in jail. You got it? Because I can violate you on the underlying charge as well.
Yes, I do.
Okay, so the contempt of court and those will be set for sentencing on March 16th at 8:30 in the morning. So when you get released from the jail, I'm gonna give you a PR bond on both of those. You're gonna get released from the jail today. As soon
Okay.
as you get out of the jail, you're gonna go to the first floor of the courthouse and you're gonna sit on the bench and check in at district court probation until somebody meets with you today. Do you understand?
Yes, I do.
We can offer you help. If you don't take it, you know, I can offer you a different kind of help. All right?
Okay.
All right. So as soon as you get out of the jail, walk over to the courthouse and wait for probation and check in and wait for them. All right?
Okay.
All right, we'll see you back the 16th, all right?
All right, see you the 16th.
All right, thank you.
Thank you, Judge. Good luck, Miss Bell.
Oh.
You're good to go.
All right,
You're
thank
all
you.
set.
Yep.
Okay. So, I have Mr. Daly and. She's interrupting him. There she. Mr. Murphy is not logged back in. Let me see if I can find him. So I think the only person I have left at the jail is Mr. McCullough, but I also have Mr. Austin. So Mr. Daly, hold on. Mr. Daly, we had you on, let me find him, just pick up. Trevor Austin.
That's right.
Now he's in custody. Do you want me brought back today on Zoom?
No,
Do you want me to set it for another day?
I'll have to get over to the jail and talk to him. I just found out about this 5 minutes ago.
All right, so Mr. Austin, would you be able to pop in like Monday morning at 8?
Yes.
All right, so on Trevor Austin, I'm gonna set him over to March 6th at 8 a.m.
Right, I made a note of that. We'll update our records here, Your Honor. I also
All right.
show on our court sheet for this morning for you a Ramos Ruiz, which shows to be a sentencing adjournment from the 23rd of February for today.
All right, so, Jesus Casares Ruiz.
I have Johnny Ramos Ruiz. What's showing on our sheet.
All right, hold on.
Judge, I have that one down for March 10th.
All right, that is March 10th.
Okay, I will make a note.
It probably got moved. Sorry about that.
It's okay. I'll just make sure our records are updated.
I think the only one I have left from the jail will be Mr. McCullough, and that's it.
Okay, would you like him now?
Sure, thank you.
All right.
All right, so I have Mr. Malaro. I have Mr. Casares Ruiz.
Yes, Judge, that's gonna be kind of like a bench conference with a plea.
Okay, do you need to meet with him or?
I do not.
Okay. And you want a bench conference?
As soon as we get a prosecutor.